India Legal presents Courts Roundup.
Hello, I'm Hisha and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. And before we begin, here's the headlines. Jammu and Kashmir Peoples Conference moves Supreme Court seeking early hearing of plea challenging the abrogation of Article 370, says irreparable impact on the rights of citizens. In view of worsening air pollution, NGT bans sale and use of firecrackers in Delhi NCR starting today midnight to November 30th. Hearing a plea of Bollywood producers sued, Delhi High Court issued notice to TV channels Instruct channel to ensure no defamatory content is displayed. And Bombay High Court denies bail to Arnab Goswami in abetment to suicide case. Goswami moves regular bail application before the session court. Alibaug seeking release from judicial custody.
India Legal presents Courts Roundup.
The National Green Tribunal has imposed a total ban on sale and use of firecrackers in Delhi and adjoining areas starting midnight of November 9 to 30th of November. The ban has been imposed ahead of Diwali to prevent worsening of the air quality already in the severe zone. Because of the firecrackers, the order will be applicable to 2 more dozen districts across 4 states and that are a part of NCR. Nationwide, it will be also applicable to cities and towns where the average ambient air quality in November last year was poor or worse, the Green Tribunal has said.
The National Green Tribunal on Monday imposed a total ban on the sale and use of firecrackers in the Delhi NCR region from midnight of 9th November to 30th November midnight. The NGT order further said that the ban will be applicable in cities and towns where the air quality is poor category. The NGT further added that in cities or towns where the air quality is moderate or below, only green firecrackers will be sold and time duration will be bursting them will be restricted to the 2 hours during festive season such as Diwali, Chhath, New Year, Christmas Eve as may be specified by the state. Currently, the state government have their own set of guidelines with regard to permitting, banning the sale and use of firecrackers during the festive season. The Arvind Kejriwal-led Delhi government at a meeting on Thursday had decided to ban the use of firecrackers as it was directly proportional to the sharp rise in the national capital daily coronavirus tally. At a time when the national capital is witnessing a spike in the number of coronavirus disease cases, bursting of firecrackers can aggravate breathing issue, thereby making people vulnerable to the infection which targets lungs. Shortly after the NGT order, the Haryana government allowed the use of firecrackers between 8 pm till 10 pm on Diwali and Guru Purab and 11:55 pm till 12:30 am on Christmas and New Year Eve. Apart from firecrackers, the rising pollution level in Delhi NCR can also be attributed to the expensive stubble burning. Delhi Air Quality Index continued to remain in the surf category for the 5th consecutive day. The AQI at 6 am on Monday was 459 and the minimum temperature recorded at 8.30 am. The AQI at 6 am on Monday was 459 and the minimum temperature recorded at 8:30 am was 10 degrees Celsius. An AQI between the range of 301 and 400 and 401 to 500 is considered to be very poor and serve category respectively. Bureau report.
We are now joined by Advocate Shivam Sharma for more update on this.
Yes, in this case, The NGT ordered that having regard to increased healthy impact of pollution by use of crackers on COVID-19 aggravating risks to life and health, which has led to ban by the government of Odisha, Rajasthan, Sikkim, Uttar Pradesh, Chandigarh, DPCC and by the Calcutta High Court on sale and use of crackers. Applying the sustainable development and precautionary principle, case is made out for issuing a directive for banning sale and use of firecrackers during November 9 to 30 in areas where air quality is poor. The NGT therefore ordered that there will be total ban on against sale or use of all kinds of firecrackers in the NCR from midnight of November 9 to the midnight of November 30. Yes.
Thank you, Shivam, for the update. The Jammu and Kashmir Peoples Conference has moved the Supreme Court seeking early hearing of the batch of pleas challenging the abrogation of Article 370 and reorganization of the Jammu and Kashmir. The application seeking early hearing has stated that the petitioner had made out a very strong prima facie case and the issue raised are being considered by the Constitution Bench of the court. Notwithstanding the foregoing, pending the final hearing of this petition challenging the abrogation of the special status of the erstwhile state of Jammu and Kashmir and the abrogation of the Constitution of Jammu and Kashmir, and notwithstanding the prevailing pandemic conditions, sweeping changes are being brought about by the centre that impact the rights of the large number of people, including the dilution of safeguards earlier available to the permanent residents of erstwhile state of Jammu and Kashmir. The application states, it further stated that these changes have been irreparable impact on the rights of the citizens of Jammu and Kashmir, including creation of domicile right and third-party right in land ownership. The application states that functioning of the court continues to be restricted till date and consequently, even though 7 months after lapse since the order of 2nd March 2020, wherein the preliminary issue of the reference to a larger bench was decided, and over a year that has lapsed since the impugned constitution orders and the Reorganization Act were issued, the present batch of petition is yet to be heard on merit. A plea has been filed in the Supreme Court challenging the constitutional validity of the draft notification issued by the Union Ministry of Environment, Forest and Climate Change concerning demarcation of 56,825 square kilometre as Western Ghats ecologically sensitive area. The petition by the NGO Karshaka Shadam has challenged the October 29, 2018 draft notification published by the Ministry on ecologically sensitive zones. Through this notification, the area of over 50,000 per square kilometre spread across Gujarat, Maharashtra, Goa, Karnataka, Kerala and Tamil Nadu has been demarcated as the Western Ghats ecologically sensitive area. Apart from challenging the wires of the notification as being violative of Article 21, the plea also seeks direction to the state of Kerala to not implement the recommendation of Western Ghats Ecologically Expert Panel, also known as Gadgil Committee. It also seeks a direction to the state of Kerala to not implement the recommendation of High-Level Working Group or Kasturi Ranga Committee. Instead, it is prayed that the recommendation of the Omen Committee to be implemented as it is claimed to be beneficial for Kerala. The petition before the Supreme Court states that the rationale behind issuing the draft notification without inclusion of the measures to incentivize green growth advocated by the HLWG and those proposed in the National Agroforestry Policy 2014 is questionable. The Delhi High Court has ordered news channels including Republic TV and Times Now to ensure that no defamatory content against Bollywood personalities are displayed on their channels or uploaded on their social media handle. The court was hearing the suit filed by 38 Bollywood production houses against Republic TV and Times Now over sensationalized coverage of the Sushant Singh Rajput case, which saw the media channels make allegations of drug trafficking against various Bollywood personalities. During the hearing today, Justice Rajiv Shatkher recorded the assurances given by the media houses that they would abide by the program code under the Cable Television Network's rule. As the hearing drew a close, the plaintiff urged the court for a direction that the defendant media houses be restrained from carrying out defamatory reporting in the interim, orally observing that it is not as if a person can say that they will not follow the law. The court proceeded to add in its order that the media houses should ensure that there is no defamatory content on their platform. The court has issued notices in the matter and posted it for further hearing on December 14th. And the Delhi High Court has stayed a Delhi government notification issued earlier this year whereby the 3-year term of non-official member of the Backward Classes Commission at Delhi, Ashok Sharma, was cut short to 1 year, extendable up to 3 years. The commission was constituted by an April 1993 notification following the Supreme Court's judgment in Indira Swane and others versus Union of India and others. The notification sought to constitute a permanent body to entertain, examine and recommend request for inclusion, the complaint of over-inclusion and under-inclusion in the list of other backward classes of citizens. As per the 1993 notification, the commission would comprise a chairperson, a chairman, 2 non-official members who have special knowledge in matter relating to backward classes to be nominated in the government and the Financial Commission. The court was informed that Ashok Sharma was appointed as a non-official member on the commission on January 9, 2019 for a 3-year period. However, through a notification issued on June 1st and a corrigendum issued on September 8 this year, Sharma's term cut short. Sharma challenged the move before the Delhi High Court. He argued that the notification issued this year were contrary to the 1993 notification, which had led to the constitution of the commission. He added that the notification cutting short Sharma's tenure were discriminatory as the term for other persons appointed as non-official member continued to be 3 years. The Supreme Court has observed that the objective of granting interim permanent alimony maintenance is to ensure that the dependent spouse is not reduced to destitution or vagrancy on account of the failure of the marriage and not as a punishment to other spouse. The maintenance amount awarded must be reasonable and realistic and avoid either of the 2 extremes, and that is, maintenance awarded to the wife should neither be so extravagant which becomes oppressive and unbearable for the respondent, nor should it be so meager that it drives the wife to penury. The bench comprising Justice Indu Malhotra and R. Subhash Reddy observed the court also noted that there is a tendency on the part of the wife to exaggerate her needs, and there is a corresponding tendency by the husband to conceal his actual income. To make an objective assessment for grant of interim maintenance, the bench has also directed that affidavit of disclosure of assets and liability shall be filed by both parties in a maintenance proceeding, including pending proceedings before the concerned family court, district court, magistrate court. Bench comprising Justices Indu Malhotra and R. Subhash Reddy observed the court noted that the factors which would weigh with the court inter alia are the status of the parties, reasonable needs of the wife and the dependent children, whether the applicant is educated and professionally qualified, whether the applicant has any independent sources of income, whether the income is sufficient to enable her to maintain the same standard of living as she was accustomed to in her matrimonial home, reasonable cost of legitimation for a non-working wife. The Allahabad High Court granted bail to 9 Thailand nationals who attended Markaz at Nizamuddin, New Delhi in March this year. The bench of Justice Siddharth was hearing the bail application filed on behalf of the applicant Hasai and 8 others with a prayer to release them on bail. The allegation against the applicants is that they are residents of Thailand and had come to attend Markaz at Nizamuddin, New Delhi. Therefore, they went to Sajanpur and their host did not give information about their arrival to Sajanpur, the district magistrate, and therefore they had been implicated in this case. The counsel for the applicant submitted before the court that all the offences alleged against the applicants are bailable except Section 14B of Foreigners Act 1946. It was contended that the applicants have been implicated on account of fault committed by Mesula, etc., who are residents of the country and were required to inform the district magistrate about their presence in Sajanpur. Keeping in view the nature of the offence, argument advanced on behalf of the party spreading of novel coronavirus in jails, evidence on record regarding complicity of the accused, larger mandate of the Article 21 of the Constitution of India, and without expressing any opinion on the merits of the case, the court gave bail orders. And it may be noted that the Allahabad High Court on 30th of September directed that the cases pending against the members of Tablighi Jamaat in Kanpur, Gorakhpur, Prayagraj, Varanasi and Lucknow zones be transferred to Chief Judicial Magistrate, Lucknow. And the Bombay High Court has refused to grant interim bail to Republic TV anchor Arnab Goswami, who was arrested and remanded to 14 days judicial custody on November 4th, and 2 other co-accused in the 2018 abetment of suicide case. A division bench comprising Justices S.S. Sinde and M.S. Karnik held a special sitting at 3 p.m. on Monday, despite the High Courts being closed for Diwali holidays, to pronounce the order on the interim bail application in the habeas corpus petition filed by Goswami and 2 other accused. It was heard advocates Vijay Agarwal and Nikhil Mengde for the co-accused in the matter, Nitish Sarda and Praveen Rajesh Singh respectively, though senior advocate Harish Salve and Abad Ponda made vehement submission seeking ad interim bail for Goswami. The bench refused to grant it. The bench clarified that the pendency of the case in the High Court will not be impeded for the petitioner to seek regular bail under Section 439 of the Code of Criminal Procedure before the concerned court. If such an application is made, the court ordered the same should be decided by the concerned court within 4 days of filing. Meanwhile, Republic Goswami has moved a regular bail application before the Sessions Court, Alibaug, seeking his release from the judicial custody. Goswami, in his application filed on Monday, has sought bail in the FIR accusing him of abetment to suicide of interior designer. The Gujarat High Court quashed charges of sedition against a journalist who published a report on a possible change in Gujarat state leadership in light of rising COVID-19 infection. The bench of Justice R.P. Dholaria accepted an unconditional apology tendered by the journalist. He had placed on record an apology without admission of any guilt for the allegedly offending article. The order quashing the sedition case reads, since the present petitioner is a young journalist and he has begun his career and that from the deepest corner of his heart, the petitioner has tendered apology as quoted above, and therefore this court is satisfied with the apology tendered by the petitioner. The sedition case was registered against Dhawal Rajnikant Patel, who is the editor of online Gujarati news portal Face of Nation. Charges were slapped against him for purportedly publishing a report on a possible change in state leadership amid criticism for the rising number of COVID-19 cases in the state. Patel also ventured to the name of the incumbent Chief Minister's successor, which led to the Crime Investigation Department slapping charges of sedition against him. The institution of criminal proceeding against Patel prompted him to seek the court's intervention in quashing charges of sedition against him. He also placed on record his unconditional apology in consideration of his youth and his apology for the heart. The High Court directed that the charges be dropped. Well, that's all for Courts Roundup. Thank you for tuning in.
India Legal presents Courts Roundup.